Can't keep on coming to court every other day. Your lordships also get fed up with us. Sorry.
Already.
If you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there is a split in the political party, which is not even addressed, which is not even claimed. Call themselves, Eknath Shinde can call himself the leader, merely because he happens to be one of 40. Splinter group of that party can be a separate political party. He will, because he is 1/3 in the legislature, belong to that party, because that becomes his original political party. None of this has happened here.
The quantum of the split, interestingly, was not defined in terms of numbers. So long as there is a split, the 1/3 is in relation to the group representing the legislative party.
Yes, I agree. Right. But that split may be minority, majority, it doesn't matter.
So long as, there is a split.
There is a split.
In the original political party.
Correct. So, that's not the case here, Malad. On 21st of June, they were in Gujarat and they were in the Northeast. Only the legislative members. And they never said there's a split. They said, we are the Shivsena. So that claim was also not there. This also creates a lot of problems. That problem doesn't confront us in this case, because most of these people then resign, join the other party, get elected, become ministers. So there is some scope for challenge to this particular provision, its constitutionality. But be that as it may, we are concerned with the earlier part of this. That if you are disqualified, you can't be a minister. Now your disqualification is pending. Matter is before the Constitution bench. Matter is before the Speaker, whichever it may be. And you are appointed by the Governor.
And also there's a provision under the Representation of People's Act where they can't contest again.
That's right. Not for this, Maharashtra. Not for the 10th schedule. That is for other corrupt practice. There's no period here. That's why I say this is subject to challenge.
Right.
Okay.
There, Maharashtra, for all kinds of other reasons, corrupt practice, and he's been convicted for X number of years. Now, Maharashtra, what is happening in a ordinary case of a dharna on a road, a trial court convicts you for 2 years and you lose your membership of the Legislative Assembly. That's also happening. We can see it, headline news everywhere. What do we do? Can't keep on coming to court every other day. Your lordships also get fed up with us. Sorry.
Already.
How many times do we give you justice? The provisions for exemption from disqualification in case of splits, as provided in paragraph 3 of the 10th schedule to the Constitution, has in particular come under severe criticism on account of its destabilizing effect on the government. Please see this, please mark this. The purpose of the amendment is that we will not allow you to destabilize the government by bulk defection. And that's exactly what has happened here. So you have to interpret the 10th schedule and its provisions to ensure that there is no bulk defection. And the concept of minority is over. Bulk majority also will be subject to disqualification. And 1/3 was a defense. Majority is not a defense anymore. There is no defense as far as the split is concerned in the legislative party.
Mr. Sibbal, notwithstanding the deletion of paragraph 3 of the 10th schedule, the issue as to who represents the political party is still a moot issue.
No.
But that has to be resolved outside the legislative party. That
No,
cannot be that cannot be still, according to you, resolved within the fold of the legislature party.
that question doesn't arise in this case because this,
No, I mean, we're not on this case, but that question as to who represents
that will happen outside the House.
that will happen outside the House. That cannot be resolved by the number of legislators within the House.
That's my only submission, Manoj.
Yeah.
How that is resolved outside the House is actually given in a judgment of this court in Brahmanand Reddy.
Brahman.
That's
I'll
a
issue-
matter of the internal constitution.
That's right, that's right. You have to call a meeting, you have to raise the issues.
internal
For 2.5 years, the gentleman was a minister.
The procedure, the bylaws of that party.
Yes, yes. That's right.
But the forum is.
You have to follow those bylaws, you have to call a meeting, you have to resolve that issue, and then you can do all this, Manoj, when paragraph 3 was there. Otherwise, Manoj, what you're doing is exactly what the object says you shouldn't allow to do, bulk defections. Toppling the government. As I said, what this would result, if you were to uphold this, Manoj, my humble submission, if you were to uphold this, then any government can be toppled, Manoj, for the simple reason you take those people, become majority, appoint your speaker, Manoj, and have a trust vote and you are in government. You don't need anything else. You don't need to have a split in the political party. That's a matter of a dispute that will arise and it will go to courts and the courts will decide in their own time. In the meantime, the 5 years will pass. So if you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there's a split in the political party, which is not even addressed, which is not even claimed. What is claimed is that we are the party. Now, we are the party can't be claimed within the legislative party.
Yes.
He was the minister. This very government never raised any issue. There is no public document saying that he is dissenting or he's a conscientious objector. Nothing. No evidence, no document filed, no evidence of that, no public statement, no newspaper report, nothing. He was the leader of the House on 21st of June. And overnight, Manoj, facts stare you in the face. The only way, Manoj, this is not what Parliament will be ready to do, the only way to remedy this is to have a 5-year period of no public post moment you defect. No minister, no public post, no public sector, no nothing. All this will stop. That's the only way. 164 1B now gives you a way out. Instead of defecting, you can resign. And then you become minister. You were a minister before, all you have to do is resign. This is the only way. If you want to maintain morality in public life, you will not be given any public office, no governorship. No remunerative post.
Kind of cooling off,
I'm sorry?
cooling off of sorts.
Yeah. Even in 361, Malaj, in fact, disqualification for appointment on remunerative political post. Capital B, Malaj. If he was disqualified, he can't hold a remunerative post. Actually, 91st Amendment, Malaj, was very careful in trying to sort of settle part of the problem. So, Malaj, if the Congress or if a small party in a state merges with another big party to form a new party, that becomes his original political party. Therefore, a member of a house shall not be disqualified where his original political party, maybe a small party, merges with another political party, and he claims that he and any other members of original political party have become members of such other political party, that is, they merge into that party, or, as the case may be, of a new political party. Both of them may form a new political party formed by such merge.
So A merges with B, or A and B merge together to form C.
Form a new party. So therefore, no disqualification. It's a merger of the political parties. Or have not accepted the merger and opted to function as a separate group. So I say, look, I don't accept the merger.
There's no compulsion to merge.
There's no compulsion. I may be majority, I may be minority within the legislature.
This will be called the unattached member?
Yes. No, but if he has not merged, he can form a separate. He will belong to the original. Supposing two parties merge and form a new party. Correct, Malaj? And he belongs to the original political party on which he won the election. He will continue to be the original political party.
I think Amar Singh sat like that.
Amar Singh, yes. He will continue with the original political party. That also issue is before the larger bench. So, if there's a new political party formed pursuant to merger, and I belong to the original political party on the basis of which I was elected, I continue to be in that original political party.
But clause 2 now again has
I'm coming to that.
requirement.
Yes, I've just come.
It is 2/3 of the existing members of the legislature.
That's a very interesting provision, which of course doesn't call for interpretation now, but it has some nuances that's important for us to understand. And normally, if 2/3 of the members don't agree, then there's no merger as far as the legislators are concerned. First, the merger takes place. Then the question arises whether you are 2/3 or not. If you are 2/3 and you agree, it is fine. It's a defense. If you are not 2/3, Malaj, then you can be a separate group. So 2/3 happens to be a defense after the merger.
This deemed is also very important,
Yes.
because what 10th schedule does is that it doesn't create a new category. By saying deemed, it is relating back to the position of the assembly as it were
Yes.
when legislators got elected and come to the assembly.
Yes.
That position will be deemed instead
Yes.
of creating a new category.
Correct. For the purposes of one, the merger of the original political party of a member of the House shall be deemed to have taken place only if not less than 2/3 of the members concerned have agreed to such merger. So 2/3 of the member, less than 2/3 of members, question defense doesn't arise. But if 2/3 of the members agree, then that's a defense. That's a perfect defense. So, Malaj, looked at it from any standpoint, these 40 people have no defense under the 10th schedule. They don't claim that there's a merger. They say that they are majority in the legislative party. They claim that because of that majority, they can change the whip. They claim that they can change the leader of the House. They can call themselves, Eknath Shinde can call himself the leader, merely because he happens to be one of 40. And so what happens, Malaj, to the political party to which he belongs? What morality are we talking about? What conscientious objectors are we talking about? Conscientious defectors is the word that I used last time. And you don't raise a voice for 2.5 years. You are the leader. You enjoy the fruits of ministership. And suddenly you say that, look, now I am free to do what I want. I can join up with the BJP. I can go to Guwahati or wherever I want to go to, and that's it. So the question that your lordships will have to ask, Malaj, how does the 10th schedule come to their aid at all? Under what provision of the 10th schedule can they have a defense? The schedule doesn't give them a defense. Whether it's a minority bulk moving away or a majority moving away. Which is when we last time were discussing this matter, this is what I mentioned. that the schedule doesn't, 10th schedule doesn't make a distinction between majority and minority. It just ensures that this habit of bulk defections, which is destroying the polity of this country, and by which governments, elected governments can be overturned. So the objective is that you should not allow an elected government to be overturned. That's the fundamental premise on the basis of which paragraph 3 was deleted. You cannot destabilize government. And if you uphold such an act through a judicial process, you are enabling future defections and therefore destabilizing elected governments, which has far-reaching consequences for the polity of this country. That's the issue that your lordships have to decide.